Good morning to all. Jay Del Rio appreciates your and welcome you to the webinar Ultimate Beneficial Owners and its Impact on Mexican Companies. Thank you for joining. Well, I am pleased to introduce Montserrat Cullen and Dan Guerra, tax partners in our Mexico City and León offices. I'm going to provide a quick intro of both of them. Montserrat graduated as a public accountant from the Institute Politécnico Nacional in Mexico City and holds a diploma in taxes and legal services from the University of Panamericana. With more than 13 years of experience in national and international tax consulting acquired at Big Four, Montserrat has participated in corporate restructures, mergers, spin-offs, share sales, acquisitions, trusts, due diligence, M&A procedures, compliance, tax consulting, deferred taxes, and analysis on the application of international treaties, among others. She is a member of the International Tax Commission of the Mexican Institute of Public Accountants in Mexico City. Dan Guerra. He is a public accountant, graduated from the University of Juarez from the state of Durango, with a master's degree in corporate finance from the University of Tech Millennium. He has over 10 years of experience as a tax advisor for local and international companies. Dan specializes in manufacturing, maquiladora, energy industries, advisory services to foreign corporations seeking to invest in Mexico. Please give them a warm welcome. And to our audience, please feel free to send us your questions during this transmission. Our experts will answer them in the Q&A session at the end of the webinar. Thank you so much for joining. I'm going to go ahead and pass over the mic to Montserrat.
Thank you so much, Alejandra. Thank you so much, Dan, for joining me on this webinar. And welcome everybody for this interesting topic that we need to discuss. I believe that the most of us that we are attending this webinar, we have a general idea that ultimate beneficial owner could means on what is the obligation about, but the most interesting thing is how to identify it. So we will be very focused on identify it and how to identify it, what are the different discussions that we have on different type of companies, on different type of groups of companies, and how we can solve these different, possibilities that we could have. We are going through this agenda, and we're trying to go since the simple to the very complicated things that we could have in our companies. At the end of the discussion, we will be happy to discuss any type of doubt or comment that you could have on this regard. So thank you so much, and I will let Dan to continue with the explanation.
Thank you, Monse. Thank you, Ale, for this introduction. Let's start with the basics. In Mexico, probably you all know about this. This is a new obligation in Mexico starting in 2022. It was part of the tax reform that was proposed by our government last year and coming to force, as I mentioned before, starting this year. In fact, the obligation means in Mexico to identify who is the ultimate beneficial owner and keep, as part of the accounting records, all the information related to them. We will be discussing during this conversation what will be all the implications regarding to become an ultimate beneficial owner, and we will be including the penalties, the lack of compliance with this new obligation. Therefore, this is on a quick basis. We will start, for example, just mention it, who can be or who shall be understood as ultimate beneficial owner. Well, in practice, pretty much any individual or group of individuals that has any interest or participation in Mexican companies. Anyone that can be identified as part of this obligation needs to be considered as an ultimate beneficial owner, and therefore to be in compliance with the obligations established in the law. Thank you. So number one, we need to identify what kind of companies or what kind of legal entities needs to be identified, needs to comply with this obligation. Number one, all kind of legal entities. We have corporations, we have LLCs, we have civil societies, etc. We have trusts, we have financial institutions, we have pretty much a lot of multiple companies that needs to be aware about this new obligation. Not only those kinds of companies, we are also including public notaries or anyone else that are involved in the constitution or incorporation or any of these new societies or new legal entities needs to be considered as part of the analysis. And more than that, you need all of these companies needs to maintain internal controls to identify, to keep updated, and allow to the tax authorities all the information required in order to comply with this obligation. So if you are thinking about, okay, let's have this kind of society, no. For Mexican tax purposes, it's pretty open the definition of what will be the entity that needs to be aware about the obligation. So any idea you may have, at least for a Mexican tax legislation, it's kind of complicated to identify any legal entity that cannot be contemplated as part of this obligation. So please, if you are thinking about any idea, please let us know. It's not as good as it sounds, but probably as part of this new consideration, please know that you need to be aware about this new obligation, and we'll be informing to you about the penalties of lack of compliance because are not business on that side. Next, please, Ale. Well, we already have what kind of entities, what we need to identify, and let's continue with origins of the concept. As I mentioned before, this was included as part of the proposal by our government in 2021, came into force in 2022, and for that purpose, it was modified and added some additional articles in our law, in our Mexican Federal Tax Code, articles 31, 32B, etc. This is part of international regulatory framework. Mexico is very famous about following all of these guidance or considerations enacted by international organizations, for example, OECD. We had a BAPS initiative that Mexico is one of the companies that already put in place all of that kind of situations in our legislation. We have some anti-abuse rules that was part of the recommendations issued by the OECD. And now we have the ultimate beneficial owner as part of following this international framework that are proposed by international organizations. So this is not new in our country. This is not new in our world. This is something that is proposed by international associations, and we need to be careful about all of these obligations in Mexico.
Yes, and also as Dan already mentioned, this is relevant because as you already see in this, I would say, precedents, we could see that this new regulation doesn't come from a tax regulation. It came from a financial regulation to kind of be transparent between all the countries and all the groups, and to try to have all the information available for any type of authority over the world. So this is relevant because in Mexico we are, I would say, one of the countries that we are always always try to be aligned with the recommendations of the G20 and the OECD and all the regulations, that all these recommendations we always try to align it on our local laws. So that's what we have in here. And in this case, what is ultimate beneficial owner? And Dan was mentioning that we need to go for the symbol. What are the individuals that we have on the top of the groups? So even though we have a group of companies where we could have, for example, an LLC, and then we have another company in Canada, and then we have the individuals, we need to go to identify the individuals, but not also the individuals. We also need to identify what is the structure of the group, because also this information is something that we need to provide to the tax authorities in case of a request. So we need to go for the individuals, but we are going to see that we have another definition of what control could be understood as. And then we have how many can exist in companies, how many UBOs. So in the regulation, we will see that we have a definitions of what could be understood as control. But also we need one definition that says that just one individual would have the more than the 50% of the interest of the company. But then we have a definition that says that if a group of individuals has more than this 50% of interest, we need to take it as UBOs also of the group. So in this definition, I always said, if we need to identify the UBOs on the companies, it's not just the one that has the most higher percentage of the interest of the company. Will be all the individuals that are part of the group, and that's relevant because we are going to have not just one, but we need to identify all the shareholders that we have on the group, and also the other I would say individuals that could have interest on the group. What obligations do we have? And we are going through this article, which is the 32B chair on the Federal Tax Code. We have this new article that gives us the idea of what could be understood as UBO. So can we go to the next slide, please? Thank you. So in this article, and we just we include the article in here because it's relevant for all of you to see what did it say. So we have in the first part that what type of group or companies are subject to these obligations. So we need to identify it for legal entities. So it could be an SA, an SRL, an SC, and any type of company that we could have in Mexico. Fiduciaries, settlers, trustees in case of trust. So we also have these kind of figures that are not companies but who have this type of obligation. So we also in these cases don't have just the definition that could be for, I would say, business trust, but also for administrative trust, for guaranteed trust. So we have this obligation for any type of trust in Mexico. Then we have for contracting parties or any other legal form. So let's say a permanent establishment, some like for example, I would say an agreement that could have this form of a kind of a legal firm, but it's not a legal entity, but it's a legal firm. So any type of, I would say, group, company, or figure would be subject to this new obligation in Mexico. So I would say it is if, for example, we see if we have a taxi in Mexico in our legal firm, trust, or company, we will have this obligation as part of our accounting records. Then, what information do we need to have or provide, or what obligation do we have? So we need to obtain and keep information in relation to these UBOs, and just in case that the tax authorities request that information, we need to provide it. In this sense, we will have 15 days to provide that information with a possibility to extend that time for 10 days more. And we need to have it. So as this new obligation is kind of part of our accounting records, and it is kind of strange because it's not information that is accounting. But in this new regulation, the tax authorities and the government says that this new information is part of our accounting records. So imagine that we are on a company that we have a financial audit statements. So if we have this service, if we are obliged to comply with this financial information, and we don't have this, I would say that these defense files of the UBO complete at the time that we are having this review, we will have a complaint, or we will have an observation by our auditor that says that we are not complying with it. So, for example, I would say for FIN 48, for purposes of the our foreign companies, if we are not complying also with this information, it could be, I would say, something that should be mentioned on a FIN 48. So that's something that is not just relevant in case of a request by the tax authorities, but also is relevant because it's part of our accounting records. Then we have another scenario in case that we are going to have a new company in Mexico. Let's say a soft landing in Mexico. We have operations all over the world or in other countries, but we are planning to start operations in Mexico. So in this case, if we are planning to start operations in Mexico and we have to open and constitute a company in Mexico, it's part of the obligations of the notaries, brokers, and any person which intervenes in the formation or execution of the contracts of the company to have this information. Financial entities and members of the financial system also need to have that information. So if we are going to constitute a company in Mexico, our public notary, which is the one that make this legal information, are going to request this information to the companies to being able to open that company in Mexico. Otherwise, if we do not provide that information, we could not open the company. So that's relevant because it's it's a new obligation, not just for the accounting records, but also to open a company in Mexico. Can we go to the next slide, please? Okay, and this is kind of what additional obligation that we have. So I already mentioned that this UBO's information is part of our accounting records, but also the tax authority says that we need to prove, in case of a request, that we are able to keep updated this information, that what kind of controls we made to identify it correctly, what was our procedure to identify it, and to have this information always updated in our current basis. No? So what do we have? Well, we need an internet control. So it is relevant also to develop an internet control for keep updating this information, and also to prove to the tax authorities, in case of a request, that we have all the skills and we have all the information and we have I would say the right procedure to identify the UBOs. So this is an additional, I would say, information that we need to have. As you can see, this is kind of a defense file that we always need to have updated in our accounting records. When this obligation should be fulfilled, as I already mentioned, in case of a soft landing, we need to provide that information to our public notary in Mexico, but also in case of a request by the tax authorities, we need to have it and provide it 15 days after the request, and we could take 10 days more to provide that information. But it's important that we don't need to wait. It's our recommendation to not wait for that request, because as you will see, this information, it is, I would say, sensitive information. It's something that is not as easy to have that information in 15 days. So it's better to have it before any type of request by the tax authorities, and also in the case that we have another type of reviews like FIN 48, or we have audit financial statements. What happens if we do not provide that information? And this is relevant. If we do not provide that information, we are going to have, I would say, different penalties. We have different penalties, like, for example, if we do not provide any information at all, if we provide information incomplete, or if we provide information which is not, I would say, the right information, it's not correct, it's not the correct information. So if we are in any type of I would say, of possibilities, we could have 500,000 to 2 million pesos for each one of the UBOs as penalty for not complying on the right way. Can go to the other slide, please. So this is I would say, a general chart. What we need to do. Well, I know we already discussed what is this obligation about and what we need to have. So I would say, as 4 different steps, which is general for all the companies in order to have this information complete, is first of all, we need to identify the UBO. So obtain, validate, and verify information. It's important not just to identify the UBOs, which I mean, so the individuals of all the groups, and in other cases will be could be somebody else, but we need to identify it. But what the tax authorities could request is, okay, how did you identify it? What was your procedures? What information you could have to prove that this UBO is the UBO. So I would say, for example, legal information of the companies, the organizational charts, I would say like a kind of a quest when we are trying to identify the UBOs, and we have this quiz, I would say, properly respond, and maybe we have, I would say, legal information, accounting information, tax information. So what we could have on these different files to prove that the UBO that we identify is the right. In a second point, we need to identify also the group. I would say this is kind of mentioned as control. So we need to identify all the group that we have. For example, the structure that we have. For example, as already mentioned, one example, which I said, we have an LLC, and then we have a company in Canada, and then we have individuals. This is a general case, but we need to identify also the information in relation to these different companies that we have on the structure. We don't need to identify the UBO of each one of the entities, but we need to identify what type of company do we have, if it is a tax resident, since when is a tax resident, and for each one of the companies. And then the information and particular information of the UBOs that we are going to discuss further. Then we need to retain information. We have internal controls to prove that what was our procedure, and also that we are able to keep updated that information, and it's part of our accounting. And then update the information every time that we have any change on the structure on any type of UBO. So if we have an increase of capital, if we have a decrease of capital, if we have a sale of shares, a merger, a spin-off, any type of restructure that we could have, not just in Mexico, but in the full structure, we need to update that information in our records. So can we go to the next one, please?
Well, we know now what are the entities that are obligated to identify who is the ultimate beneficial owner. What happens when you are incorporating a new company in Mexico? What happens with existing companies? You already know also that there is no filing obligation so far. As long as the tax authorities are not asking for the information, you are free to comply with this. However, we strongly recommend, as my partner just mentioned it, to have all this information available, because once the tax authorities is asking for the information, it is only 15 days to gather the information and provide to the tax authorities. So we strongly recommend you identify who is the ultimate beneficial owner and to start keeping all the information. What is the information that you need to gather for all of these ultimate beneficial owners? Okay, I can tell you, well, we have at least a lot of information. We have here full names and surnames of the individuals that are identified as ultimate beneficial owner, alias in case they have, date of birth, and when applicable, if it is in the legislation, it is not, it is that date of death. How can we have someone that is already a beneficial owner? Well, if this is the case, you need to identify sex of the person, country origin, and nationality, if there is one than one, population register code that we have here in Mexico called CURP, or something equivalent, country jurisdiction in which it is tax resident for tax purposes, type and number of legal or official identification, the tax ID, marital status, and not only for the person that is considered as ultimate beneficial owner, but it is also applicable to the couple, to the spouse, in case there is, and it is also applicable all this information for that person. What else? Contact information, email, and phone numbers. Home address, tax domicile, relationship with the legal entity or status, interest of the legal entity or the risk of the trust or legal figure, description for the interest, direct or indirect, number of shares, place where the shares, partnership, interest, stakes, or other equivalent rights are deposited or are in custody, a specific date on which the individual acquired the status of UBO, date on which a change occurred in the interest or controlling legal entity. Once the tax authorities ask for the information, and in case there is a subsequent change in the ownership of, because of a legal structure, as my partner mentioned it, spin-off, transfer of shares, merger, etc. You also need to update the information to the tax authorities. You have, in addition, another 15 days once they will have implemented all of these kind of structures, and they have a termination interest or control a legal entity or any legal form. So as you can see here, it is a lot of information. So if you don't have enough time to identify who is the ultimate beneficiary within the 15 days provided by the tax authorities, this is basically the reason we are suggesting to start now to gather the information, to have available the information, and to implement the internal controls in order to identify or to update the beneficial owners. This is for all kind of companies, but in addition, next slide, please, Alan. In addition, if you have identified, because other ways we will be discussing later, you will need to also have available name, designation, or corporate name of the legal entities, trusts, or legal forms that have interest or control over the legal entity, country jurisdiction of establishment, constitution, or registration, country jurisdiction of residence for tax purposes, tax domicile, etc. As you can see here, it is a very sensitive information about what will need to be available for the tax authorities when they ask for this information. Let's imagine for a moment that you are already identified, and for a second, you know that you are a new BO. Then what happens if this is the case? Is there a personal obligation, additional obligation for myself once I am identified as a new BO? Well, the fact is, for Mexican purposes and based on our current rules about this new obligation, there is not any additional obligation for the person that is identified as a UBO. The only obligation for this person is only to provide all the information requested once the tax authorities are asking for that information. So you are thinking about updating something or registering in Mexico for this purpose? No, there is no specific obligation on this. You only need to provide the information requested by the tax authorities, or as part of the internal controls implemented by the company you are participating and you are considered as a UBO. You need to have this defense file that was suggested by my partner. So if you're thinking about, okay, do I need to register? No. Do I need to complete with any filing obligation? No. Does the company is obligated to another filing obligation? No. So at the end, as you can see here, is only to provide information. But what would happen for you in case you identify as a UBO? Well, for the company, being registered as a UBO results in a great oversight of tax authorities, because they can have the general, in some way, already identify who will be the person that is identified as who has the direct control, the direct benefits of the company they are operating in Mexico. As you can see, something we have some similar with the anti-laundering law in Mexico. So the fact is that if you are identified, you don't need to be worried about it, only just to provide information. And for the company, it's only to have to facilitate to the tax authorities to compliance with all of the change information agreements they have with other countries, with other jurisdictions. So at the end, it's not very complicated for the person that is identified as the ultimate beneficial owner. It's not complicated to comply with this obligation. We understand that there is sensitive information about that, but as long as you implement these internal controls and be able to have available the information once the tax authority is asking for the information, it is the only moment that you need to take care about the obligation. So, in conclusion, our Mexican tax legislation is very strict about this new obligation, but as I just mentioned before, it's not having additional obligations for the person that is identified as ultimate beneficial owner. So there is no issue on that. Just to provide information, I am being so persistent on this part of the discussion. So, well, we now have to identify how you can be an ultimate beneficial owner. What is the definition of interest in a company? And we don't have any specific, let's say, definition about that. But what we only have is, if you have a direct control in the company, you can be considered as an ultimate beneficial owner. Or if you are on an indirect matter, having a direct control and indirect control of the company, you can also be considered as ultimate beneficial owner. Let's see for a moment the chart on the right of the screen. You have the individual that is owning the company. In Mexico, there is a direct control. We can have, in addition, as my panel say, you have the individual in Canada, then you have a holding in Canada, then a subholding in the United States, then you have the company in Mexico. You will need to identify all of this chain of the ownership in the company in order to identify direct or indirect control. And that will be the person that needs to be analyzed if it can be considered or not as ultimate beneficial owner. If that case is not, as what we will be discussing during this webinar, well, that is all on that part. But please note that if you only have, let's say, 1% of the company, that doesn't mean you cannot consider it, because as we mentioned during the discussion, individual or group of individuals that are having this control in the company or direct control, those persons that can be identified as ultimate beneficial owners. So please don't be worried about it, but please take care about this new obligation, and just to confirm with your advisor regarding this new obligation if it's applicable to you.
Yeah, and this thing that Dan mentioned, I think, is very relevant, because it's not just, I would say, in general way, we could identify the individuals, which are the shareholders, even on a direct or indirect way. But also we could have these other figures and these other, I would say, structures that allow us to think that somebody could be understood as UBO. So, for example, in the case that we are having this new company in Mexico, that we are going to constitute that company, and in one part of the article that we already mentioned, we have that anybody that could be, that are part of this constitution of the company, could be understood as UBO. So let's say, what could be understood as somebody who is part of this incorporation of the company? In my first point of view, I would say the different parts. So the shareholders that are planning to constitute the company. So these are one of the one that could be considered as UBO. Okay, right. But then we have a deed of constitution, that some legal documentation that some other individuals are included on that constitution. So, for example, a commissary in a group could be understood as UBO. And this is what I mean. All of the I would say people which work in Mexico as public, I would say as in the constitution of the company, have this type of conversations in order to determine which could be considered as part of the constitution. So that's why we are mentioning that, because on the general procedures in Mexico, in order to constitute a company, we already have these controls, not just for the shareholders, but also for somebody which are part of the constitution of the company in the legal documentation. So that's relevant. And also in this, I would say, chain of ownership, we have this regulation. This is an omnibus tax rule. We already discussed the article on the law that says which one could be understood as UBO. But what happened if we could not identify the UBO, or if we are not able to identify a UBO under the article that we already mentioned? So this omnibus tax rule says that if we have I mean, first of all, it says chain of control, no? So if we have any type of change of control or chain of ownership, we have this obligation to identify, I mean, any type of change, any type of I would say of control in our group, and give us also some regulations in case that if we are not able to identify it. So if we could not identify it, and let's set some examples, because I believe the article, the article on the Federal Tax Code includes all type of entities, all type of agreements, any type of trust. I mean, it's any type of figure that we could have in Mexico. So what other cases could be understood in this omnibus tax rule? So we don't have any examples, but it says that if we are not able to identify under the article on the Federal Tax Code, we could identify the the sole administrator, or the individuals which are in position to have any type of control. For example, the board of directors, any equivalent body that we could have in Mexico, we could identify that individuals that are part of this, I would say, board of directors of this sole administrator in Mexico to consider as UBOs in Mexico. What is the general idea? The general idea is that these individuals are a part of a group of individuals that could have any type of control or some control over the Mexican company. And we have these questions always with some of our clients. For example, what happens in case we have a company, for example, which is a trust, I would say a foreign trust, or maybe we have a company which is public in any foreign country, and we are not able to identify the individuals which are part of this, I would say, fund, trust, or a public company in a foreign country. So in these cases that we have an impractical way to identify it, and we have we are not able to identify it because it's not possible. It's confidential information. It's information that it is not easy to have. What could be the idea? Can we apply this omnibus rule and identify the sole administrator or the board of the directors in Mexico? That's something that could be understood that is a supplementary of the article on the foreign tax code. I would say no. It's not a supplementary. It's not something that we could understand. That if we comply with this, we are, on a very good way, in a very good position with the tax authorities if we do not identify the individuals. But we know that we don't have particular rules that the tax authorities give us to understand this omnibus tax rule as supplementary. But as we don't have this information, or we don't have any pronunciation by the tax authorities, what I recommend, that we recommend as JDA Rio, is to try to identify the individuals as much as possible. If we have an impractical way to identify it, because any of the reasons that I already mentioned or any other, let's go to identify at least the information on the administrative body on our company. And also we're going to discuss later what I would say administrative body, or what board of directors we need to identify, which will be the Mexican board of directors, or should be the one on the top of the group, or what could be understood as board of directors. I would say this is case by case analysis. It's not something that apply on a general way for all of our group of companies. So that's something that should be analyzed. And should be analyzed, what are the activities, what are the real, I would say, the power or control that these individuals has over the company. And this is relevant also to document all of this control, all of these activities, to try to prove to the tax authorities that these individuals are the ones that has this control over the company, under the definition to the omnibus tax rule and the federal tax code. Can we go to the next one, please? And this is I would say a general idea. If we have a change of control, for example, in this case, the red ones, which is Jorge Palomares and Rigoberto Marino, which they are director, they have a direct participation on one company in Mexico. So these two, which on the, I would say, if we consider the 41 and the 51%, they have the 100% of the interest of CC in Mexico. So we could understand that those individuals are the UBOs of the first company in Mexico. But then we have Transforma, and Transforma has on one side the 51%, on another side on TI services the 49%. So what could be understood on Transforma as UBOs? This is just on a general idea of percentage of interest on different companies in Mexico. So we could understand that Jorge Palomares and Rigoberto Marino are part of the individuals that has interest in Transforma, But also in the other part, we have Regina Morales and Valentina. Can we go to the next slide, please? Okay, in the next slide, we have this Regina Morales and Valentina Rosales. And then we have, those two are the, has the interest on MAKT expertise. So we have this 100% for this side. Then we have the other percentage on Jorge Palomares and Rigoberto Marin. And we have this case where Grupo TIB has the 51% of TI services, but the shareholders are variable partners. This is a public company that, as you all know, this kind of companies could change the shareholders day by day. I mean, it is kind of very complicated to have updated this information, and also this is confidential information. And even the board of directors, or maybe the directors, financial director, the tax director in Grupo TIB doesn't have this information available. This is confidential information. So what we could do in this case? So as we could not identify it, and I would say in all of the different panels and in different conversations with other, I would say lawyers, other accountings or different firms in Mexico on the discussions and also in our committees, we believe that the general position of the tax authorities is, I don't mind if you don't have the chance or you are not able to identify these UBOs in these variable partners. You need to have it. But let's say, okay, let's try to have it. But what if we could not obtain that information? At least we could comply with the omnibus tax rule to prove that, for example, the board of directors of Grupo TIB has the control of the group and all the different position of the company, or if we want to pay dividends, make a capital reimbursement, or maybe we want to sell shares, we want to include a different, I would say, a shareholder or any type of real, I would say, decision of control are taken under the board of directors. So we need to prove that. In order to prove that, even we have a different shareholders over the world because it's a public company. These individuals, yeah, they have the participation of the company, but maybe they could not have the position of control over the company to take decisions and change something relevant on the group. So that's our recommendation. We believe that at least at some point the tax authorities will give us more rules and will give us more definitions under these kind of structures that it is impossible or it's very complicated to identify the UBOs. Okay, so this is in relation to the company incorporations, and we already mentioned we need to take care of what information we need to provide to the public notary. What could happen is that the public notary requests us the information in relation to the UBOs. They could give us some questions and some information that they would need to prove which one is the UBO. And also, it is relevant to mention that is not information as you've seen on the list that shared with us, that is not just information in relation to the UBO, also is information in relation of, I would say, the husband or the wife or any type of figure similar to that, and we need to provide information for both. This is sensitive and relevant information that we need to take care in the Constitution. For example, if we are making a constitution of a company, it is better. For example, if we have a commissary, we need to include a commissary for sure in the deed of incorporation. But we could include as commissary somebody which also is the shareholder of the group. So it is more easy to provide that information. But in case that we include a commissary, which is an external advisor, imagine to try to obtain that information from an external advisor, which is also providing services, and is not somebody which has some interest over the group. So this is something relevant. we could give us some recommendations in the case of some land in Mexico to try to make this process easier for you with the public notaries and also with the tax authorities to try to comply with everything in the most easy way as possible. And I was saying, in this corporate structure, we already mentioned that it is important to have all the information in relation to the structure. So if we have, and I know this structure could be as simple or as complicated as possible, but we need to identify the different companies or figures that we have in between to the Mexican company and to the shareholders or individuals. And also it's relevant to mention that we in Mexico have one informative tax return, which is related with the shareholders in Mexico. If we have any change in Mexico of the shareholders, and I would say this is direct shareholders. So if we have a group where we have an LLC, a Canadian company, and an individuals, in this informative tax return, if we have any change and we need to provide this informative tax return, we are just mentioning the companies which are on the top. So will be the LLC and the other shareholder, which is in Mexico, because we need to have two shareholders in Mexico. So we'll be the two shareholders, even though these two shareholders are companies and not individuals. This new regulation is focused on the individuals which are on the top, but also we need to have to identify what kind of control we have in the middle, which are companies or different figures. In case of public companies, anonymous trust that we already mentioned, it is relevant to consider what I already mentioned, which is the chain of control. Could be very complicated to have this information updated because we are not able to have that information, I would say, in a more easy way. Imagine, for example, our fund in Thailand, in another place. I mean, could be difficult to have this information updated. And this is another example. This is for an incorporation of different groups. It's just kind of I would say the same one, but it's just a recap on a final idea where we need to identify all these different shareholders, individuals on the top of the group. And maybe in the case of variable partners, which are on the stock or as a public company, we could, we need to try to identify the UBOs, but if it's not possible to identify it, at least we can go with the omnibus structural and identify the board of directors of the Mexican company. And we have this question always, which is, we need to identify the board of directors of the Mexican company, or we need, I would say, the Grupo TIB or TI Services or Transforma, or which one we need to identify. So it's not a real definition on the law, on the article, but we believe it should be of the Mexican company, the board of directors of the Mexican company. But I would say as we don't have a regulation which is clear on that definition, our recommendation is let's try to identify both. I would say the board of directors of the Mexican company, but also let's try to identify the board of directors of the foreign company, because in some cases the one that take that decisions or the decisions over the Mexican company, relevance over control, could be the board of directors of the foreign company. So in this case, it's analysis case by case that should be made. And for sure, it is relevant not just to have the general idea that is the board of directors of the Mexican company, but because in some cases could apply for both companies, or in some cases could be somebody different, the one that takes control over the company or that takes the decisions in relation to the bills.
Well, now that we know all the relevant implications about being a UBO in Mexico and what are the companies that are obligated to identify their UBO, we now have what are the penalties of lack compliance. We already mentioned it, but this is very important. We have three important brackets here. Number one, for 1.5 to 2 million pesos for not obtaining or keeping information available for the tax authorities. Please note that each of these brackets can be applicable, and it is per each ultimate beneficial owner. So you have in some way identified 2, 3, or 4 ultimate beneficial owners, so you need to make the operation, the penalty times the number of the persons that can be identified as ultimate beneficial owner. So, as mentioned about months a couple of minutes ago, if you have doubts about who can be because you are having at the ultimate level a trust or fund, or it's a public company, or it's a university, or any other kind of or transaction or legal entities or legal figures that can be part of the chain of control or chain of the ownership of the company, well, it could be better for you, for the operation, to identify all of them. And because we don't have a specific guidance provided by tax authorities, what happens in this case? The only topic that we have here is, in case you are not able to identify all of one or more of the ultimate beneficial owners, you can go for the board of directors or the sole administrator, the person that is having that kind of appointment in Mexico. The second bracket is from 100,000 to 1 million pesos for not keeping the information updated, and from 500,000 to 800,000 for providing information but incomplete or not accurate. So if you are having some mistakes in the information that are provided, you are also entitled to, the tax authorities are able to claim a penalty in that scenario. So if you can see here, are not cheap the penalties for lacking of compliance with this. Even if we don't have a specific filing obligation, this is very important, because like the lack of compliance with this obligation can give us the tax authorities the right to claim these kind of penalties per each ultimate beneficial owner. We include, as part of our participation in this webinar, what happens at this moment in the United States. On terms of time, I will only explain some of the basic difference between what happens in the United States and Mexico. Last time we reviewed the United States. It is under a proposal not doing by the IRS, it is doing by the FinCEN, that is the Financial Crime Enforcement Network. There is an obligation to report in some specific cases. In Mexico, it is only when asset tax authority is requested. In the United States, it's a filing obligation. In Mexico, you need to report each of the UBOs, and for the United States, it is not that extensive the list. You only have the full legal name, date of birth, current residential address, business street address, etc. And we as a UBO is pretty much the same, but as in Mexico, we mentioned 15% of ownership of the company. For the United States purposes, is 25% of the ownership. So this is very different. In Mexico, it is information to keep as part of the accounting records, and the United States at this moment is only is filing obligation. When a US company needs to report, well, within 14 calendar days for the registration of new company, and not later than 1 calendar year for existing companies. Penalties are not as expensive as in Mexico. You have some civil penalties for $500 for each violation, for each day of violation, and can be up to $10,000 for as part of the penalties. Other important considerations is a reporting entity is also required to disclose information about a company applicant. A company applicant is any individual that will file a document that creates a domestic reporting entity of who first registered a foreign reporting entity with the Secretary of State or similar office in the United States. Well, let's have a quick recap on here. We all know now with ultimate beneficial owner who are able to be appointed as ultimate beneficial owner. What are the specific obligations for the company that needs to identify the ultimate beneficial owner, and also the specific requirements in order to keep the information, what happens with existing companies, what happens with new companies, and something very important, the lack of compliance, the amount of the penalties that can be imposed in Mexico that are not cheap. So this is very important just to make you aware about this obligation and what are all the implications. We strongly suggest to start keeping this defense file in case tax authorities ask for the information, just in order to be able on a timely manner to provide information to the tax authorities. And what you need to know in case at the ultimate level you have a company that is owned by a fund or a public company, or you can be able to identify on an individual by individual who are the ultimate beneficial owners, what happens in that case. Even we don't have any clarity in our Mexican tax legislation, it is very important just to take a conservative position to have all information available, and also to implement internal controls that gives the possibility to the Mexican company to provide information, to keep updated information, and to be able to provide information anytime the tax authorities is asking for the information. I don't know, Monse, anything else you would like to include?
Yes, Dan, thank you so much. And I believe one very good recommendation to all of you, and that it's a recommendation that we gave to our clients, is to not, I mean, first of all, not wait for the request by the tax authorities. I mean, let's try to make this defense file, because we could have some penalties that are higher penalties to each one of the UBOs, but also is something that could be observed by our auditor if it is the case. Also something that is part of our new obligation to have it since January as part of our content record. So let's try to comply with it. And in order to comply with it, another good recommendation is to make a good procedure to identify, to keep updated, and also try to identify which one under the company could be the one to help you to identify that information, to keep that information. And if this is confidential information, is sensitive information, try to have also some legal documentation that gives the company, gives the UBOs the confidence to provide that information, that this one person on the company that will keep that information, that will have the obligation to keep updated. You as company could have confidence on providing and also to keep that information on a safe place in case of a request by tax authorities. Let's also not have this information available for everybody, but have that information in a very safe place, in an electronic safe place, or a physical safe place, to have that information in case of a request. So another good recommendation, and the last one, is like try to be close to your advisors, to try to see if you have the I would say the internal controls stronger as possible. If you want to develop an internal control and you need help on that, if you need help to identify the UBOs, or maybe just to have a double check on what information you have as proof or evidence of your procedures, and gain the identification of UBOs, and try to also to have all the information as possible, in order to make your defense file as strong as possible in case of a request. So this is, I would say, the three principal recommendations that I want to give to our to the persons that are invited today. Thank you, Dan.
Yes, thank you so much. It was wonderful hearing from both of you. Thank you so much for giving us all this interesting information. So I would like to tell the audience that we will now start off with the Q&A session. So already, I have here the questions from the audience. I'm going to go ahead and read one. Monse, Dan, feel free to answer them to the one that corresponds. So here we go. At what level should the board of directors be identified if this scenario applies?
Yes, as I already mentioned, this is relevant to analyze case by case. Let's say a company where we have a Mexican company which has on the top a shareholder which is a public company. So we are going to identify the board of directors because we are not able to identify each one of the individuals in this case. So it is quite relevant that maybe the board of directors will be for the Mexican company. But let's imagine a group where the board of directors is a group of companies. On the top of the companies in Canada, which is the one that take all the relevant decisions of control over the company, and we just have a service company in Mexico. It's not a company which is, I would say, maybe just a distributor of the group of companies, and it's for sure not the most relevant activity over the group, but is relevant. But the decisions are taken over the board of directors of the Canadian company. So I would say this analysis should be made case by case. But if we are not able to identify the UBO or the individuals, let's try to identify the most information as possible. So maybe the recommendation is to have the information of the board of directors of both entities in case of a review.
Thank you so much, Monse. So I think this would be great if that person can contact us, and maybe you can explain to them a little bit more in detail with their explanation. So let me go ahead and go with the next question. Do I need to identify chain of control and ownership for the UBO?
Well, as we stand in this conversation, I will say yes. It is very important to identify all the persons that can be able to have some control or interest in the Mexican company. It is not just a matter of who is the ownership, who is having only shares in the company. You need to identify all the persons that have some specific interest and can have in some way decisions to take over or the control of the company, to take administrative decisions, or even to appoint some specific functionaries within the company. So anyone, any person that can have some kind of interest in a Mexican company can be considered as a UBO. The answer is yes. Even we don't have any specific guidance that we just explained during this conversation, it is very important to identify or to try to identify as much as possible or all these individuals that can have some kind of interest in the Mexican company. The answer is yes. We strongly suggest that as part of the analysis for identifying the UBO. Once you have available information, then we can start in some way to say, okay, this person can be considered, this other person not, but at the end, you need to identify all of the individuals in some way having an interest in the company, depending upon ownership, of the shares or any interest, or as part of the legal fund that is having some decisions controlling the company, etc. You need to be aware about this. And it is very important to start doing the analysis as part of the whole group in order to identify who is the ultimate beneficial owner and avoiding the impose of penalties for the Mexican tax authorities.
Thank you so much, Dan. I think that this topic is very relevant and interesting at the moment. So right now, I was reading more questions that we have, but unfortunately the time has ended. So I would like to thank everyone for accompanying us today. And please, the following questions that we see here, we will contact you so we can maybe have a quick call and go into detail. So we appreciate your company today, and thank you so much for being with us. So it was a great having all of you today. Thank you so much, Monse and Dan.